What I'm going to be talking about is under the title Liberal Democracy and the Christian Citizen. And when I was asked to talk about this, I thought, well, there's lots of ways that one can go about talking about this issue. So what I've decided to do this afternoon is to focus on the kinds of conflicts that I think Christians are going to be facing over the next decade or two in terms of the public square. Now, of course, as that great philosopher Yogi Berra once said, predictions are difficult, especially about the future. So, you never quite know, right? Who would have predicted, for example, that the day that the Berlin Wall fell, that it was going to fall? So, history has a way of sort of faking us out. So, what I'm going to talk about is just what I see in terms of what's going on in the law and the issues where I think Christians have to shore up their own beliefs and to be able to present them in a way in the public square in a clear and precise fashion. Now, what does liberal democracy and the Christian citizen have to do about apologetics? I mean, this is an apologetics conference after all. Well, I want to focus on those aspects in the public square in which Christians get challenged, and I think the challenges largely arise from the fact that there are assumptions that people make about the nature of the Christian worldview, about our beliefs that are mistaken, and we have an opportunity to be able to present and defend our beliefs in a way in order to correct that, but just not so that they can become Christians, so that the church can be protected. And you'll see that as we go over some of these issues. Now, I got the idea, I've been thinking about this for over a decade. Doug mentioned the book that I published called Taking Rights Seriously, which I happen to have a copy with me. The inspiration of the book is the result of an exchange that I had at Texas Tech University in 2004. I don't know if any of you have ever been to Lubbock, where Texas Tech is. People from the moon go there and say, wow, what a wasteland. Well, I was at Texas Tech to talk about actually another book I had published in 2003 called Law, Darwinism, and Public Education. And that book dealt with the question of whether it was legally permissible to teach intelligent design in public school. And in my lecture, I went over the different legal arguments for and against teaching it. I went over the sort of history of constitutional law in which courts dealt with these sorts of questions. There were 2 Supreme Court cases and several lower court cases. But after my lecture, there was a gentleman in the audience from one of the science departments who raised his hand and didn't have a question. He looked at me and he said, all you've given us are religious arguments. It was an odd sort of charge because actually I didn't really give any religious arguments. I actually shared with him and the audience arguments that people happen to offer for beliefs that they hold that happen to align themselves with their religious beliefs. But he said, all you've given us are religious arguments. And I paused for a moment and I looked at him and I said, wow, I'm relieved. I thought you were going to say they were bad arguments. Now, it was at that moment that something crystallized in my mind, that much of the disagreements that arise today in the public square, whether it's questions about abortion, whether it's questions about religious liberty, whether it's questions about marriage, or any of these issues, I think a lot of it has to do with what people already believe is plausible or reasonable to believe. That is, the way in which as Christians, we want to defend, let's say, religious liberty, is going to have more to do with what people generally believe is rational or reasonable than what the law may say. And for those who have ever studied the philosophy of law, this would put me in a camp called legal realism. I don't know if any of you have ever studied jurisprudence or philosophy of law, but legal realists essentially say this, that what judges and justices ultimately do, even though they'll tell us they're being principled, is going to be deeply influenced by what they already believe is reasonable or rational. Now, I think that they should be principled. I'm sort of in a normative sense, I think that's what they should do. But the reality is they're very much influenced by what the general culture believes, by what how they've been formed intellectually and spiritually. And so that's why I think it's up to us as Christians to have a voice in the public square, not so much to convert people, although we want that, but to make sure that the church is protected. So let me first begin by talking about what is liberal democracy. You may have heard that term before or variations on it. Well, liberal democracy has a very long history, and the idea of liberal democracy actually comes from the two terms, liberal and democratic. The liberal side really refers to what are sometimes called fundamental rights. We think of those rights, for example, that are found in the Bill of Rights: freedom of religion, freedom of speech, freedom of association, and so forth. The democratic side has to do with the fact that there's a sense in which the people have a say-so on who leads them. Now, of course, the way the American system has developed, we don't live in a pure democracy, right? And rightfully so, because the American founders understood that there was a fatal flaw in pure democracy, one that Plato saw, and they read Plato. And that was that if you had a pure democracy, that could lead to something like mob rule. And so they created a system that included certain legal instruments like constitutions, right? And a divided government, right, between the three major branches, and of course state governments with their own sort of quasi-sovereignty. And the whole point of that was to make it more difficult for tyranny to develop, right? Because they had a robust and rich understanding of human failure. So, but there's another element that's often ignored, and that is what is called civil society. What's civil society? Well, that's just a term that refers to a variety of institutions that are overlapping, that are non-governmental, that we kind of take for granted, whether they're sort of small businesses, families, churches, synagogues, civic groups. And that's where most of us are formed, both morally and spiritually, and what we learn about how to conduct ourselves as citizens. But when those institutions, what are sometimes called subsidiary institutions, begin to atrophy, what takes over? The government takes over. And the government doesn't do as well of a job as those civic institutions. And as you can see all around us over the past 15, 20, 30 years, those elements of civil society have been affected, and I think in a negative way. So when we talk about the Christian citizen in liberal democracy, what we're talking about is, what does it mean to be a Christian citizen in this kind of regime that we occupy, right? We live in a regime that is unprecedented in the history of the world. Much of what we take for granted, the fundamental rights that I've mentioned, the relationship between different governments and different legal instruments and civil society, is something that we benefit from, but somebody like the Apostle Paul would not have recognized. Although one of the things it's interesting, when I was working on an earlier book called Politics for Christians, I reread the New Testament from beginning to end with an eye towards political stuff. And so there's that encounter in the book of Acts chapter 16. Paul and Silas are in jail, and they find out the lictors. That's what my translation calls them, those that are sort of in charge of the lower level administrators in the Roman government that's occupying that little sliver of the world, finds out that Paul is really a Roman citizen. And what does Paul do? Paul doesn't say, "Thank you very much," and moves on. He goes, "I want to speak to your boss." And it's really fascinating because you see there Paul exercising the rights of his Roman citizenship. And he doesn't simply walk away. What he wants, not only, his wrong has been remedied already, right? He's been released. But I have a sense when I read that he also is showing concern for his fellow Christians who themselves may be treated badly as a consequence of these mid-level administrators administering the law in a way that's unjust. Right? And so he says, and what does Luke say in Acts? He says the magistrates are a little nervous, right? So one of the things I learned from that reading of the New Testament when I was working on Politics for Christians is that there are numerous places in the New Testament, where obviously politics is discussed, but one of the things that stands out is that when put in positions of conflict, many times Christians exercise their rights of citizenship, and we should not be afraid to exercise those rights as well. And of course, we have far greater influence than those individuals have ever had during their lifetimes. I mean, it's always a mistake to take one age in the history of the Christian church and sort of treat it as the golden age. Because if you think about it, every age faces different sets of problems. So imagine you're in the first 2 or 3 centuries, Christians are in a very small minority. But what happens after, let's say, 5 or 6 centuries where most people are converted? Well, it turns out that you have to figure out how to run stuff, right? And so in some ways, as there's a larger majority or a larger group of Christians, we have greater responsibilities as a consequence. And today, although there are fewer Christians in America than there were 30 or 40 years ago, we still are a sizable minority in this country, and most people actually identify as Christians. And so we have a responsibility that maybe somebody like the Apostle Paul would have never imagined, but maybe somebody in the 7th century would. So that's sort of my understanding of liberal democracy and how we can think about it as Christians. So let me focus on 2 types of conflicts that most likely will be with devout Christians for a while. And they both involve conscience and coercion. And if you look on the outline that I prepared for you, they involve cases in which issues in medicine, healthcare conflict with religious belief. I'll be talking in a few minutes about one of them, the HHS mandate. But we think of, for example, issues that are going to arise, especially people that are in healthcare professions, who are physicians, let's say, put in a position in a hospital, supposing you're required, if you're in residency, to do rounds that involve OBGYN work, including abortions, assisting in abortions. That's going to happen. That sort of conflict, and it's already happened in certain venues throughout the United States. Or supposing you're a nurse and you're told that they give you an exemption from participating in abortions, but then they tell you, yes, but if a patient comes up to you, you have to refer that patient to a doctor who performs abortion. Does that involve a kind of unjust or illicit cooperation with evil? How far does it go in terms of when you, let's say, assist somebody in a particular way in terms of your culpability as a Christian, right? Second kind of issue that we're going to be faced with, and we have been faced with over the past 5 years or so, and that has to do with anti-discrimination laws and same-sex marriage. We're all familiar with the cases, and I'll talk more about them in a few minutes, cases involving vendors who are in what are called expressive businesses or expressive professions, such as florists, photographers, bakers, who are asked to cooperate with a same-sex ceremony, even though they believe that such ceremonies are in fact not really marriages at all. Right? And not that they're not even not marriages, but that they somehow are cooperating by doing this with what they think is immoral. These are the kind of issues that we're going to be facing, and I want to focus on them because I think they bring out, the deep conflict between one way of thinking, which is dominant, especially in academic circles, and I think the way in which, let's say, many Christians believe. Now, I think the only way we're going to get anywhere with these issues or resolve these issues, it's going to depend on 2 things. And I've already alluded to one of them. And that is the background beliefs of the judges about what counts as reasonable. And secondly, whether contemporary liberalism can keep its promises. Now, I'm going to first talk about the background beliefs of justices. To help us understand that, I want to go to the case Hobby Lobby versus Burwell. This was a case, a 2014 case that went to the U.S. Supreme Court. The U.S. Supreme Court voted 5-4 to allow Hobby Lobby and another business to be exempted from the HHS mandate. What's the HHS mandate? Well, the HHS mandate was a regulation issued by the Secretary of Health and Human Services. It was not part of the Affordable Care Act. This is my students. In fact, this semester I'm teaching a course at CEU called Law and Religion. And I asked my students what before they read the case or before we go over it, well, what exactly happened in Hobby Lobby? And every one of them that raises his or her hand will say, well, the Hobby Lobby wanted an exemption out of Obamacare. That's technically not true. The Affordable Care Act actually does not include anything about a contraceptive mandate. What the Affordable Care Act did was give the administrative state, in terms of the Secretary of Health and Human Services, to issue regulations. And this actually brings up another issue that obviously we're not going to deal with, is the degree to which regulations should count as laws, which is a big issue and a big debate among legal scholars today. But it wasn't in the original ACA, and the reason for that is if it had been, it would have not gotten the votes. Some of you may remember that there were about a half a dozen to a dozen congressmen that wound up voting for ACA, and they did so under the assurance that there would be nothing like the HHS mandate in the bill. But the bill actually gives the Secretary of Health and Human Services to issue regulations to do that anyways. So what did the HHS mandate do? Well, it required businesses of a particular size to provide certain types of quote-unquote preventative care to its employees. There were exceptions. There were exceptions for religious organizations such as churches and synagogues, and then certain companies were grandfathered in. But then there were certain companies that were for-profit companies like Hobby Lobby, Mardel, and Costa Wood Products, which was the other family business that was involved with this case, that said that they could not directly pay for some of these birth control methods. Why? Because some of them, 4 out of the, I think there were 27, resulted in some cases, in the destruction of an early embryo. That is to say, most of these birth control methods would prevent fertilization, but if fertilization occurred, it made the uterine wall incapable of receiving the embryo, and thus it would die. And so the owners of these corporations said, these family-owned businesses, for us to actually give money to our employees to pay for these things, we feel puts us in the position of immoral cooperation, material immoral cooperation with evil. And they wind up suing, not under the First Amendment, but something called the Religious Freedom Restoration Act. What's that? It's called RFRA. The Religious Freedom Restoration Act was a law passed by Congress in 1993. It was the consequence of a case called Employment Services versus Smith. What's that? It's about two young men who are part of a Native American church in Oregon, and they ingested peyote as part of their sacrament, as part of the church, and they were drug counselors. And so they were fired from their job, and the state of Oregon would not give them unemployment insurance. Okay? And so they said this violated our First Amendment rights. The Supreme Court ruled, and Justice Antonin Scalia wrote the majority opinion, and Justice Scalia said if there's a generally applicable law, that is, that law was not passed intentionally to target the Native American practitioners, if it's generally applicable and neutral, even though it happens to violate or burden your religious practice, it's constitutional. Everyone was up in arms about this. Liberals, Democrats, progressives, and in fact, in the last show of national unity that I can remember on a legislative matter, Congress passed, I think the Senate, it was 97-3, and the House did it on a voice vote, passed the Religious Freedom Restoration Act. And what RFRA did was this. It said, if there's a law that burdens religion, even if the law was passed not to intentionally target the religion, the burden is on the government to show that that's the only way that it can get what it wants. That is to say, there's no sort of way that it can write another law that can get what it wants and give an exemption to these particular people. Well, as unluck would have it, the Supreme Court overturned it when it applied to state laws, but it never overturned it when it applied to federal laws. The HHS mandate was a federal law. So that's how we get RFRA. And that's why Hobby Lobby and the Green family and the Hahn family both sued on the basis of that. They said, this burdens our religious belief, and the government can get around this. They can directly pay for these devices to the people themselves. They don't have to have us be the sort of, they don't have to coerce us to give the money so that they can purchase it. And they wind up winning 5-4. Now, there's another question in the case. Is Hobby Lobby a person under RFRA? It's a corporation, right? And the court said, well, yeah, of course, corporate entities can be legal persons. After all, if you tripped and fell at the supermarket, who do you sue? The supermarket, right? Which is a corporate entity, right? So corporations can do bad or good things. So I'm going to tie this into the interesting thing about, I'm going to tie this into this idea of what judges think is reasonable. So in the majority opinion written by Justice Alito says this. He says, the owners of the businesses have religious objections to abortion, and according to their religious beliefs, the 4 contraceptive methods at issue are abortifacients. They have a sincere religious belief that life begins at conception. Now, there's actually nothing wrong with that, I think. I think that's actually correct. One of the problems that I raise in my book, Taking Right Seriously, with this way of framing the issue, is that the Hahn and Green family, in fact, are making the argument that it's their religious belief that's ultimately being burdened by the mandate. But the way in which they defend their religious belief is not simply appealing to, let's say, the deliverances of Scripture or what their pastor told them. They actually believe that they can make reasonable arguments as to why they believe embryos are full-fledged members of the human community and they ought not to be forced to cooperate with their destruction. That is to say that the embryos are really persons. And you'll see this in a moment, this tendency in the story I told you earlier with the Texas Tech case, right? By saying that a particular belief is religious. And again, there's nothing wrong with that. And in terms of the law, Justice Alito has to say that. But for a lot of people, to put the adjective religion in front of a belief is equivalent to saying that it's nonsense. So the reason why I responded the way I did to that gentleman at Texas Tech, in fact, after I said that, my response to him, I told the audience, I said, I want to tell everyone what's really going on here. What this gentleman is doing is simply putting the adjective religious in front of my view, and that's just code for this is really stupid, right? Because we don't do that about other sorts of things. We don't say, oh, well, that's just chemistry, right? You know, oh, that's just his aesthetic belief. Well, we kind of do that, right? We say beauty is in the eye of the beholder, right? In any event, to get an idea of why I think this is a mistaken way for Justice Alito to have framed it, I'm going to look at Justice Ginsburg's dissent. Justice Ruth Bader Ginsburg wrote a blistering dissent in this case, and she says, a quote, and you'll see it on the quote on your sheet, with the exemption the court holds RFRA demands for employers with religiously grounded objections to the use of certain contraceptives extend to employers with religiously grounded objections to blood transfusions, Jehovah's Witnesses, antidepressants, Scientologists, medications derived from pigs, including anesthesia, intravenous fluids, and pills coated with gelatin, that is, certain Muslims, Jews, and Hindus, and vaccinations, Christian Scientists, among others. According to counsel for Hobby Lobby, each one of these cases would have to be evaluated on its own, applying the compelling interest, least restrictive alternative test. There's not going to be a test here, but that's actually a little what she's referring to is the way in which courts evaluate a law that burdens a religious citizen's practice under RFRA. That is, if there's no other way that the state can get what it wants, that is, it has to have a compelling interest. In other words, they have to have a really, really, really good reason, right? Not much help for the lower courts bound by today's decision. There's an overriding interest in keeping the courts out of the business of evaluating the relative merits of differing religious claims or the sincerity with which an asserted religious belief is held. Approving some religious claims while deeming others unworthy of accommodation would be perceived as favoring one religion over another. So her argument is essentially a kind of slippery slope argument. She's saying, look, if we carve out an exemption here for Hobby Lobby and the Hahn family, which own the wood company, we're going to have to do it for everybody, right? And Justice Alito's response is, well, no, the courts are going to go and evaluate each claim individually. So in this case, we see that the government can sort of get what it wants to the employees. They don't have to do it through Hobby Lobby. Of another case, that may not be it. And then Ginsburg says, well, wait a second. Do you really want judges to have that much power? After all, they're going to be evaluating the plausibility of religious beliefs. And we shouldn't do that. My view on this is that judges can't help but do that. And I'm going to just mention a few cases. Some of you may be familiar with these legal cases. They go back for some time, one over 100 years old. These cases involve different kinds of laws. So some of you may be familiar with the case called Wisconsin versus Yoder. That case involved an Amish family that wanted to exempt their children from compulsory education. And the Supreme Court said, you know, the Amish are really good at educating their kids. They've done it for generations. Yeah, they should get an exemption. Which means what? The court's in the business of evaluating whether the Amish educate their kids well. The cases involving intelligent design and creationism. The courts in those cases said, this is unscientific and therefore religious and therefore violates the Establishment Clause. They were evaluating the quality of those beliefs. There was a case involving something called the Santeria religion. Some of you may be familiar with that. That's an unusual sort of Caribbean faith that sacrifices animals, cuts a chicken's head off and people dance and pray around it. And so the city of Hialeah in Florida didn't want that. So what they did is they created a statute that was able to include kosher killing and butchers, but not the Santeria people. And the Supreme Court said you can't gerrymander that way when it comes to laws about religion. But however, if supposing the Santeria group was like, let's say, executing 3-year-olds, right? I mean, so it's pretty clear that the Supreme Court is going to make certain judgments about what laws are reasonable or not. This is why I think people that are friends of Hobby Lobby, and I include myself among them, friends of Hobby Lobby have to remember that it's just not what the law says per se, but it's how judges think. Because the next generation of attorneys that are coming up in the ranks, those that will eventually become clerks to the Justice Ginsburgs of the world, are being formed and nurtured in a climate in the legal academy where religious belief in some venues is considered to be prima facie irrational. And so even though in many ways, when it comes to this case, the law is on our side, that doesn't mean it's going to be interpreted in a way that's necessarily friendly to our beliefs. Now, imagine, if you think back in American history, we have different types of religious dissenters in America. We had at the American founding Quakers, and then eventually the Amish, right? And they stood out because they were pacifist groups, right? And so in fact, George Washington, who led the Revolutionary Army, exempted the Amish and Quakers from compulsory military service. eventually in the early 20th century passed conscientious objection statute, right? In the 19th century, we also had another dissenting group called the Mormons. And they began practicing what they called plural marriage. And so what happened, U.S. Congress passed a statute that forbade the practice of polygamy. Now, why were they able to do that? Well, at that time, Utah was not a state. It was just a territory. And Congress votes on the laws for territories. And why is it that the Mormons don't get a break, but the Amish and the Quakers do? My view is that the reason why is because even though most Americans at the American founding were not pacifists, they still see that pacifism is not an implausible view, that they could see that there's something in Christian thought where you could come to the conclusion that pacifism is correct. But in terms of plural marriage, absolutely not. My point is this, that I think what had a lot to do with the different types of treatment has more to do with the plausibility structure than it has to do with necessarily what the structure of a constitution or a set of statutes may assert. We just went over in my class at CU about 3 weeks ago the case Reynolds versus the United States, which is the 1876 Mormon polygamy case. And I'd say that from just the expressions on my students' faces that a majority of the students were not sympathetic to the court's view that the law was justified. That is to say, most of them probably, if they had their druthers and were on the court, would have voted that the law that Congress passed to ban polygamy was unconstitutional, that it violated the free exercise rights of the Mormons. Why? Because we have a generation now that is more detached from a sort of traditional ancient view of marriage, right? In some ways, plural marriage is actually more ancient, right? But the point is my point, the way my students react to that case has absolutely nothing to do with the law per se and whether it's constitutional. It has a lot to do with what? What they already believe is plausible and permissible, right? And they will find ways to justify it. So, let's go one more thing about the Hobby Lobby case. So, the way in which, for example, Justice Ginsburg and others who think like her probably think about what the Hobby Lobby folks believe, the Green family, is this. They probably think that, it's clear from the example she uses, she thinks they're irrational. And she probably thinks that it's a dispute between faith and reason. In fact, a lot of times, if you ever have talks with people about any of these issues, what will people often say? They'll say things, well, that's just your religious belief, a kind of variation on what that Texas Tech professor said earlier. But the right way, I think, to think about issues like what was going on in the Hobby Lobby case, that is, what is concerning assisting the destruction of embryos. Really, the question is, what is an embryo? Is the embryo one of us? And that is not a quote-unquote scientific question per se, although it does involve science. And it's not really a theological question, although it certainly touches on theological anthropology. It's really a philosophical question that has to do with the deeper question of who and what we are and whether we can know it. And so the dispute between, let's say, those that believe that these abortifacients are okay and those that don't, like the Green family, is this. It actually is a dispute between two understandings of the nature of reason. So why is this important? Well, as JP pointed out in his lecture this morning, there is a kind of intellectual gravitas that goes along with connecting your view to science, right? So years ago, there was a writer, Cornell Law School professor, Sherry Colby, who wrote a piece about embryonic stem cell research in the second of Bush administration's prohibition of federal funding of that. And she said, well, that may be their religious view, but the question of whether the embryo has a soul is a theological question, not a scientific one. Therefore, to withdraw these funds, in fact, is to impose a religious view on people who don't hold that view. But at the end of the day, it seems to me, the real dispute is between two different understandings of the nature of the human person. Why is this effective for the other side? Well, think about it. If you think of reason or science as connected to reason, right? The exercise of reason is the basis of science, and science is employed in medicine, right? So the whole issue in Hobby Lobby or in the embryonic stem cell research case is about medicine and health, right? But if you, let's say, no, this is wrong because embryos are human persons, they ought to be protected, and your view is labeled as faith, what does that mean? Well, you are not in any way associated with reason, which is the ground of science, which is the ground of medicine. And so I think the best way to think about these issues is to think of them as two contrary and contested understandings of the nature of the human person, which is ultimately a philosophical belief, a philosophical dispute. It's not a dispute about science. All right, I want to move on now to the second point that I want to make, and this will bring us to some of these recent cases involving vendors and their refusal to cooperate with same-sex ceremonies. And here I titled this under the promise of contemporary liberalism. Well, what do I mean by contemporary liberalism? We've all heard the term liberalism before, and we all kind of have a rough idea of what liberalism is. But in philosophy, in the discipline in which I've been trained, liberalism is a kind of term of art, and it refers to a set of beliefs about the nature of government and the individual that we get from certain thinkers that come out of an era which Professor DeWeese talked about, the Enlightenment. And some of them have names that you're familiar with: Thomas Hobbes, John Locke, Jean-Jacques Rousseau, Immanuel Kant, and John Stuart Mill, living from all the way from the 16th through the 19th century. And there's much in those thinkers that influence the way in which we think about everything from religion and law to the nature of government and the nature of the individual. And in fact, if we have time, I have in my notes a very brief discussion about John Locke. I don't think I'm going to have time to talk about Locke, but if we do, I want to say a few things about Locke and something he had published in the 17th century called the Letter on Toleration. And it was a letter that he wrote, actually it's a little book, that had a profound influence on many of the American founders, including Thomas Jefferson and James Madison. Some of you may be familiar with Jefferson and Madison's works and writings on religious liberty. And to this day, the Supreme Court will cite those works. They're almost like sacred texts. If America were a church, they would be our sacred texts, and they still get cited and still debated upon by a variety of justices. Now, what I mean by contemporary liberalism is a little different. Its roots are in Hobbes and Locke and Rousseau and Kant and Mill, but it has a different twist to it. And to get a sort of a sense of this twist, I have a quote in your notes from John Rawls. John Rawls was a philosopher who taught for quite some time at Harvard University. He died in 2002. Probably the most influential contemporary liberal philosopher. In fact, his followers are sometimes called Rawlstafarians. This is what he says the problem today is. This is the problem of the contemporary world. Quote, "How is it possible that there may exist over time a stable and just society of free and equal citizens, profoundly divided by reasonable religious, philosophical, and moral doctrines?" So let me repeat it. How is it possible that there may exist over time a stable and just society of free and equal citizens, profoundly divided by reasonable religious, philosophical, and moral doctrines? He wrote this in 2003. I couldn't have written 2003. He'd already died. That would be quite amazing. It's his third posthumous book. Yes, I'd rather be, I hope to be a professor emeritus, not a professor posthumous. No, he wrote it in 1993 in a book called Political Liberalism. And he writes the book, it's the early 1990s, and if you look at the way American history had America had really changed between, let's say, the mid-1950s to the late 1980s. You had, starting probably in the early 60s and through the early 70s, certain segments of American society beginning to question sort of traditional understandings of human life, death, sexuality, and they began questioning whether they should be reflected in our laws. And so what happens over that time is that laws on, for example, on pornography, contraception, sexual conduct, begin being either changed by legislatures or overturned by the Supreme Court. In fact, there's a series of Supreme Court opinions roughly from the mid-60s through the late 70s where the Supreme Court obviously overturns restrictions on abortion, Roe v. Wade, restrictions on contraception, Griswold versus Connecticut, and then several laws, the famous Miller case concerning obscenity. And you see this change. And the court has not found yet the right to suicide. It actually refused to find that in 1997, but obviously we saw in 2015 same-sex marriage, and that goes back to 2003 to a case called Lawrence versus Texas, in which the Supreme Court overturned Texas's anti-sodomy statutes. And so you have these series of cases, but during this time there's several philosophers that kind of give intellectual heft to the jurisprudence of this time. And some of these names may be familiar to some of you not. John Rawls, who I've already mentioned, Ronald Dworkin, who died 4 years ago, Thomas Nagel, Judas Jarvis Thompson, and many others. What they offered was a particular account of liberty that appealed to epistemic modesty. What's epistemic modesty? Well, I think Gary and JP have already mentioned epistemic or epistemology already, but it just refers to how we know things. And so to have epistemic modesty is to say, well, I think that's right, but I think the other guy is reasonable in his or her view. In fact, in many ways, our jurisprudence on religious liberty kind of has built into it a kind of epistemic modesty, that the state should not have an established church. Not that none of the churches couldn't be right. It's just that there's other goods at stake, and there's certain liberties that ought to be allowed for human beings to flourish, even if that means that people could make mistakes, right? So, to quote here from Rawls, all of these thinkers, by the way, argued that on these issues, these sort of fundamental questions about the human good, there are a variety of reasonable, though contrary, comprehensive doctrines. By the way, comprehensive doctrine is a term these guys use, and it just means worldview. It is what people believe about the good, the true, and the beautiful. Christianity is a worldview, Marxism is a worldview, and so forth. So, for example, Rawls says that it would be unjust to coerce one's fellow citizens based on any one of these doctrines. Thomas Nagel distinguished, quote, between what justifies individual belief and what justifies appealing to that belief in support of the exercise of political power. So what is Nagel saying? He's saying, I can be reasonable or rational holding my belief, but the other guy, even if I am rational and reasonable, he can't coerce me to go against what I think is reasonable, even if what he believes is reasonable. And this is not an unusual way to think, right? I mean, we all know people that even within, let's say, the Christian community, who we think are mistaken about, let's say, a doctrine or a belief, but we don't think that it's a crazy thing that they believe, right? We think, well, they just are reading Scripture wrong, but I can see how they can see it, right? So they're sort of applying that kind of thinking to politics. Ronald Dworkin, in his book, Is Democracy Possible Here?, says, a tolerant secular society could have no reason for embracing freedom of orthodox worship without also embracing freedom of choice in all ethical matters, and therefore freedom of choice with respect to the ethical values that are plainly implicated in decisions about sexual conduct, marriage, and procreation. It's interesting what Dworkin is doing here. What he's saying is, we should treat people's disagreements on sexual matters and other sorts of controversial questions like we treat religious belief. Okay? This was written, by the way, in 2006. So this sort of thinking that you find in Dworkin, Nagel, and Rawls dominated the way in which most liberal philosophers and jurists assessed coercive laws that tried to enforce a traditional moral position. The strategy was the first to claim epistemic modesty. So something like this: too many really smart people armed with good reasons from established and well-respected but different moral traditions disagree on this matter. Something like that. And then to make the further claim that in such a state of profound, sincere, and irreconcilable disagreement, the state should err on the side of liberty. Thus, for the political liberal, the traditional moralist, that is the person that holds traditional views on these matters, may be both right and in the majority, but she has no justification to legally coerce others to conform to her view. So, according to this thinking, you may be right, but that's not enough. You have to show that the other person is absolutely irrational. And that's really difficult to do because not many people can even agree on what counts as rational. Okay? However, in the past decade or so, this political liberalism has developed into what I call hegemonic liberalism, a view that seems to eschew the epistemic modesty of its predecessor while emulating the project of the traditional moralist. That is to say, the church chat lady today is actually a secular progressive. Well, isn't that special? Remember that? Well, you don't want to do flowers for that wedding. We have to find you. Boy, you don't remember the church chat lady, do you? I got to do some of my other impressions. You remember me, don't you? I feel your pain, I do. All right. Darn, I can't be in charge of the White House interns program. By the way, after the Super Bowl, I told my students at CU, don't feel bad, the Falcons won the popular vote. So what you have today, so for the political liberal, for the Rawls, the Nagel, the Dworkin, the government should not only restrain its hand on matters of moral controversy, it should in some cases go out of its way to offer exemptions. And so I mentioned earlier cases like Wisconsin versus Yoder, and there were other cases where the Supreme Court went out of its way, and in fact, the federal government went out of its way to carve out conscientious objection statutes for pacifist faiths. They passed RFRA in 1993. But for the hegemonic liberal, the role of the state is to make men moral as he understands morality. It is to scrupulously enforce social justice by direct coercion of the actions, speech, and private associations of those who remain unconvinced by and unwilling to provide assistance to the moral trajectory of the common culture. And we see it all over college campuses today, right? We see speakers shouted down, right? We have a kind of almost exaggerated emulation of the traditional moralist, right? Found in sort of the opposite political point of view, right? I don't want to hear this, right? I don't want to see this. I don't want you to say that, right? I think this is a total movement away from political liberalism. Now, what I argue in my book, Taking Right Seriously, is that the majority opinions in several state court cases have in fact embraced this, have shown this shift from political to hegemonic liberalism, and as a consequence, I think they diminish the importance of religious liberty. So I just want to briefly go over those cases and then kind of give you a way of looking at these cases that I think is often left out of the mainstream media. In fact, much of what I'm going to share with you in the next few minutes is something that I actually shared with members of the philosophy department faculty at CU Boulder. I was invited in September to lead a faculty colloquium on my book. I'm humbled to say that my book was won the American Academy of Religion selected as one of the top 5 books of 2015, which I'm still stunned about because the American Academy of Religion generally does not hold my political views, or most of its members, and so I was invited by the philosophy faculty to talk about the book, and so much of what I'm going to share with you now in terms of thinking about this question is what I shared with the faculty there. The most well-known cases are, of course, the baker in Colorado, the photographer in New Mexico, and the florist in Washington State. In each case, the proprietor declined to do business with a same-sex couple who tried to procure their services for a ceremony that celebrated the couple's wedding. The courts in every case ruled against the proprietor. And the proprietors offered different arguments. In some states where there was actually a state RFRA, they appealed to that. Some of them appealed to the First Amendment, others to other provisions in the state constitution. None of it worked. In each of the cases, the couples won. And in all three cases, what's interesting about all three cases is that the defendants, that is the baker, the photographer, and the florist, argued that they had in fact not violated anti-discrimination laws, since their decision to decline service was based on the nature of the event with which they were asked to materially cooperate and not on the sexual orientation of their prospective customers. The courts didn't buy that. This is in fact what the New Mexico Supreme Court said in response to that argument, and which actually gets cited and repeated by the other two courts. Quote, when a law prohibits discrimination on the basis of sexual orientation, that law similarly protects conduct that is inexorably tied to sexual orientation. What I want to argue is that kind of reasoning totally misunderstands the nature, at least in this case, of Christian marriage, and what it means, not just in terms of the law, but what it means in terms of our theology. Again, what the court says here is that a wedding is simply a conduct, quote, inexorably tied to sexual orientation. The fact is, that's not the way most serious believers, even if they're not Christians, they may be Jewish, they may be Muslim, that's not the way they understand marriage. People understand marriage in different ways, right? To some people, it's just a piece of paper, right? To others, it's a good investment. In fact, if you Google a good investment in marriage, the first thing that pops up is a Forbes article about why marriage is a good investment. I found that out because when I was working on a paper, I wanted to have a footnote to show that people actually do say that. And it's there. But for many or most citizens, weddings are like baptisms, bar mitzvahs, burials, and ordinations, and they're not like bachelor parties and birthdays. They're inexorably tied to a transcendent reality to which these events point and by which they are imbued with meaning and significance. For these citizens, an authentic wedding, whether civil or sacramental, marks the beginning of what many people call a natural marriage. And here I'm going to quote my favorite philosopher, Thomas Aquinas. A natural marriage it participates in the natural law, which participates in the eternal law. Thus, for the civil law to require that such citizens either cooperate with what they cannot in principle believe to be a natural marriage or suffer financial penalties is almost a paradigmatic case of what Thomas Jefferson wrote while he was the governor of Virginia. He says, quote, no man shall be compelled to frequent or support any religious group, place, or ministry whatsoever, nor shall be enforced, restrained, molested, or burdened in his body or goods, nor shall otherwise suffer on account of his religious opinion or belief, unquote. To see why this is so, I'm going to give you a fictional case that has nothing to do with marriage. It's the fictional case of somebody I call Russell Less, a professional photographer who happens to be a devout Southern Baptist. I have a friend named Russell Moore, so this is Russell Less, who's a well-known Southern Baptist. Let's say that one of his clients is Aristotle Jones, who is Greek Orthodox, and he tells Russell that he would like to hire him to photograph the baptism of his newborn son, Socrates. As a Southern Baptist, Russell holds to the doctrine of believer's baptism and thus does not believe that the baptism of Socrates would be an authentic baptism. In fact, if Socrates were to become a Southern Baptist in his teenage years, Russell would tell him that his infant baptism did not count and they would have to be baptized again. Russell tells Aristotle that he would be more than happy to photograph the entire Jones family, either individually or collectively, in or near any body of water, including pools, rivers, and gushing fire hoses. However, Russell explains he cannot materially cooperate with the performance of a ceremony in and near water that he is convinced is not what Aristotle and his family think it is, and authentic baptism. For Russell, as with Aristotle, baptism is a practice required by his faith because it is commanded by Christ. However, as Russell understands that command, only believers can be baptized and babies aren't believers. He admits to Aristotle that other Southern Baptist photographers may have a different opinion on whether they would participate in the ceremony, but he cannot in good conscience do so. Aristotle thanks Russell for his candor and friendship, and a week later, Russell finds a Catholic photographer who is more than happy to take pictures at Socrates' baptism. Except for the neighborly ending, this story is almost a perfectly parallel to the same-sex wedding cases. This is because for most citizens, baptism, like a wedding, has transcendent significance, even if some of it the participants, attendees, or observers cannot see it that way. That is, in the case of, for example, people who treat baptism as sort of perfunctory celebration, right? People do treat baptisms that way, as they treat weddings, right? My wife and I grew up in Las Vegas. We know all about perfunctory weddings. We were married in Las Vegas, but not at one of those wedding chapels. And we were both sober. Well, at least one of us. No, So a judge who takes rites seriously, I think, could easily distinguish Aristotle's religious beliefs from his liturgical practices, just as the judges, I think, in the same-sex marriage cases should have been able to distinguish the liturgical practices of the vendors with the ceremony. To be sure, given everything that I've said, and I want to leave some time for questions, to be sure, our public questions become more complicated and our judgments of our adversaries become more difficult if, in fact, we take rights seriously, but I think justice demands nothing less. Thank you. So we have, about 5-10 minutes for questions? Or 10 minutes, okay. So, yes?
Yeah, what do you think are the imperatives and the limits of businesses in creating civil society?
I'm sorry?
What do you think are the imperatives and the limits of businesses in creating civil society?
Did you say impediments or?
Imperatives.
Imperatives.
Sorry.
Well, it depends on the nature of the business. Every business is different, right? You've got major corporations where you have shareholders. That's different than, let's say, a mom and pop store in a small town. I think if you're a Christian going into business, I think, it's going to depend on the nature of the business, right? I mean, if you have a general store, that's going to be different than, let's say you were a baker or a photographer, or let's say a tax. Let's say you're a tax consultant, right? All those, are going to have, they're going to have different purposes or different ends to them. But I think no matter what business that you engage in, as a Christian, I think you have to be honest and do things well. And so, what was the imperatives and
limits?
Limits.
The boundaries.
Yeah. Gosh, I'm immediately thinking, what if you're a tax consultant? And my mom actually does. My mom and my dad passed away 2 years ago, but they had a tax business and she still runs it. Yeah, what happens if somebody comes in and says, "Hi, I'm a prostitute, could you do my taxes?" I think you don't. But on the other hand, though, now there's an interesting aspect to this. Are you really then cooperating with what they're doing, right? I'm not sure you are, right? You actually may have an opportunity to witness to the person, right? As long as it doesn't involve you in any way supporting the business, and you may have to tell the person. I think you should say, what you're doing is immoral. And this is a Nevada problem, by the way. A prostitute comes in to have her taxes done, but so I don't know. I mean, the limits. I think the best you can do is sort of come up with general rules of what it means to be virtuous in anything, but when individual cases arise, I think you're just going to have to use a business illustration. You can't do everything in the wholesale. Some things are just going to be in the retail.
Sure. Thanks.
So. Yes,
Dr. Beckwith, thank you so much. My name is Ben Crenshaw. If you believe that politics and jurisprudence are downstream of culture, how do we go about changing the plausibility structures of these judges? How do we get at their culture, their milieu? Is it the educational establishment or what?
It's a great question. I think there is no, let's do this program and 2 years from now things will change. I think Christians of all sorts have to first start preaching to the choir, because it's not clear whether the choir necessarily agrees. That is to say, I think we have to find ways to educate our people. We have to be intentional in our Christianity. And that means to develop a much richer spiritual life, and to maybe, check out of the world a little bit. The past 3 or 4 years or so, even though I've written a lot about politics and law, I'm not as involved as I was in sort of everyday politics. And I have found it to be sort of refreshing and liberating. I now think about when I get speaking invitations, I'm more interested in doing things for my fellow Christians than I am sort of speaking at the University of Pennsylvania Law School, which I did 2 years ago. And that's wonderful to get those sort of prestigious invitations. I think we have to kind of convert the church. And the other thing we have to remember is that that we can't take anything for granted, because we live in an age that is ahistorical and rejects tradition, right? So when let's, for example, a new piece of technology arises, and we think, oh, everyone's doing this. Why? Why do we have to follow, right? So every school's got to have an iPad. Why? By the time I get these kids, they're screwed up because of those iPads, right? So, we have to sort of think about how we interact with culture, and that means that we may have to live in more close-knit communities. Right now, this year, my wife and I are living a half a mile from the Boulder campus at CU, and we walk to church. And I walk everywhere, and there's a different kind of psychology that arises when you sort of walk and you see somebody from the church, or you see somebody from school, or one of my students the other day, I saw she was walking. She was on her skateboard. She wasn't walking, and she saw me and she goes, she was taking my philosophy and religion class, and she goes, I Googled you. You're a Christian. And I said, yeah, and she goes, so am I. And she told me that this class I'm teaching it's basically a kind of introduction to philosophy of religion. We're going over things like existence of God and, miracles and things like that. And so she says, oh, my pastor's I'm using your notes in a Sunday school class I'm teaching. I didn't know that. That's pretty cool, So, my point is that I think we have to build stronger, closer-knit communities. I'm not saying we should be Amish, but that would be an improvement. No, I'm just kidding. But there is a sense and I found myself, again, I tell this story. Actually, speaking of the Amish, I actually published a piece on this about a year ago. When I was 18, I went to a summer camp in Cimarron, Colorado for Youth with a Mission, YWAM. Some of you may have heard of YWAM. They were sort of the big thing when I was a kid. It was Last Days Ministries and YWAM and Winky Pratney and some of you may remember some of these names. So I went to the summer camp, and I met these kids that were Mennonites. Now, I didn't know what they were. I didn't know their denominational background. But I asked them who their favorite Beatle was. And they said, we don't know who the Beatles are. What? You don't know who the Beatles are? And they began telling me about how they grew, how they were, their parents, kind of forbade them from watching certain things. They had never watched television. And I just thought they were so deprived and oppressed. Then after 2 weeks of hanging out with them, I realized that I was the deprived and oppressed one, that I was largely driven by popular culture, and they were far more liberated than me. And so now as an adult, I think back to that time, and I think that now, especially today with the pervasiveness of social media, and you just can't escape it, right? You go to the doctor's office and they make you watch Jerry Springer, right? It's like, enough already. Is there a corner of the world where there's silence, And so I think we have to kind of renew ourselves, and that means not only education. It's just not about facts. It's about developing virtues and living in community and holding each other accountable. So. Right. Yes, I see that hand. That's my Billy Graham impression. You up in the balcony, take that leap of faith. No,
I was just going to ask. So you said it was the Religious Freedom Act, right?
what?
So you were talking about the Religious Freedom Act.
Yes, yeah, RIFRA.
At what point does that break? At what point does the religious belief become so absurd, regardless of the religion, that you just simply cannot allow that to happen?
Good question. I don't think there's one single answer. In fact, that's why when I was going over Ginsburg and her dissent, the reason why her counterexamples I think work for her is that in her mind, what the Green family believes about embryos is no different than what the Christian Scientists believe about the absence of medicine. So I think it's just one of those cases where, and this is why I bring it up, we just have to recognize that if as Christians we want to gain exemptions, we actually have to make a case in the public square that our views are plausible. And of course, the downside to that is that people could still walk away saying that they're implausible, but I think we just have to get our hands dirty. So I don't think there's sort of one criterion that works. I think this is why, again, I think the Mormons don't get a break, but the Quakers do. So.
Well said.
Thank you. All right, this gentleman, yes.
Yes, we're seeing a lot of an influx of immigrants that are coming in, Islamic countries that are polygamous and are married to multiple wives. Do you know of any cases that are dealing with that or addressing that problem? And another point is, how soon will the $35 billion that is promised by Saudi Arabia to convert Americans, how soon will their dollars affect and impact our legislatures or legal scholars to basically adopt polygamy as
I don't know much about the second half of your question about the money and funding that. I don't know much about that, but in terms of the legal question, I actually had a question. My midterm exam actually had a fictional. For those who have ever gone to law school, there's a way of giving legal tests called fact patterns. You give a fictional case and you ask the students to sort of detect the issues and what cases are important. And so I actually had in my test a kind of Muslim polygamy case. There is a case, and I forget what state. I don't think it's gone to court yet in terms of, it's not gone to trial yet. The difficulty is going to be because there's a difference between the legal recognition of a marriage and marriage. So right now, there are people in this country who are in polygamous unions, but they've only married under the law one of the spouses, but everybody else lives together, and they may have been in a religious ceremony. So the question that a court's going to have to face is, should the government recognize the other unions? And again, I think it's going to come down to what the judges and the justices are going to think is plausible. And everybody used polygamy as sort of the slippery slope in the gay marriage debate. Now what's happened is that there's been a spate of law review articles and books that have come out in the past 3 years and saying, yeah, that's right, that's where it leads to it, but that's okay. So I think, again, the answer, the same answer as I gave to the other gentleman earlier, that is, ultimately these issues are going to have to be resolved in terms of making a case for the reasonableness of our views. Having said that, though, I doubt, given the strong sort of egalitarian impulse that we have in our culture, polygamy, that is, one man married to, or having, technically, by the way, in polygamy, the man is actually married to each woman. The women are not married to each other. So when he dies, there's actually several marriages. So it turns out that it's still one man, one woman, but it just happens to be that each of them has the same husband. If you can sort of get your mind around that. So getting back to our egalitarianism today, I don't think that's going to fly. I think what the court will say is you'll have to allow women to have many husbands, right? Or let's say to have, a marriage between, 2 men and 2 women or something like that. So at the end of the day, I think one reason why I don't think mass polygamy at least in the immediate future, is going to become law is that they'll come up with some sort of pragmatic economic reason why it's a bad idea. Too many tax deductions, or something like that. It'll be some sort of law and economics argument. So,
Thank you.
Thank you.